Hi, Jeff Mersace here, and we have with us Evonne Hopkins of Hopkins Law Firm, and she's going to talk to us today a little bit about, the area of family law. So, Evonne, what steps should people take after a divorce in terms of estate planning?
So I think this is the number one mistake that people actually make after they go through the divorce process. So divorce is so grueling, and the litigation, if the case is highly contested, people are just exhausted. So when they get through the process and they finally get that divorce judgment a year and a day later, what they forget to do is do things like change the beneficiaries of retirement accounts that they may have gotten as part of the divorce process, or change their wills and their trusts and the beneficiaries in those wills and trusts. The last person on earth I would think you would want to be your power of attorney or your healthcare proxy would be your ex-spouse, especially in a highly contested case. And so what oftentimes happens is that people are just so exhausted by getting through this kind of marathon that they don't want to be bothered changing their estate planning documents. And then something happens and their healthcare proxy is their ex-husband, which is not who you want, or your ex-wife. And so I think that it's extremely important that they get with an estate planner and figure out what needs to get changed, what account beneficiary information needs to be changed, make sure they don't have any joint property held in each other's names anymore, and have that in place and not delay.
Okay. What if people are separated but not divorced? How does that affect estate planning?
So there are numerous ways under the law that a spouse say you separate and you're living in two different houses, but you don't have a separation agreement and you're not divorced yet. Well, and you're so mad at your ex-spouse that you run to an estate planner, get them off their will and get them off every possible account that you can get them off of. Well, if you were to pass away, then that spouse, because there's no separation agreement in place and there's no divorce yet, that spouse can then, under the law, apply and receive a portion of your estate, even if you totally take them out of everything. And so that's a big, it's an opening that most people don't realize that's available. And so if they enter a separation agreement, most separation agreements have waivers of those things. But if you don't have that separation agreement, or you haven't had an attorney draft your separation agreement, then it's a problem.
Okay. Can you explain a little bit about how guardianship nominations work in estate planning? I see a lot of confusion around this until I counsel my clients.
So what happens is that people get separated, and sometimes they have joint legal and physical custody, or one has primary physical custody. So legal custody is just the ability to make decisions about where health and medical and religion, major decisions. Physical custody is where the child lives. So if a parent is still a custodian, whether they have visitation, whether they have full-blown custody, whether they have joint physical custody, they're still a parent in that child's life. And therefore, if the other parent were to die and designate someone other than the parent to be the guardian of the child, that's not going to fly. And the parent, that surviving parent, is going to have first dibs, in essence, on that child. Now, there are ways for a third party to try to get involved, but it's much less effective after the person dies. It's more effective for that person to have been designated way earlier. And that kind of goes into third-party custody and third-party grandparent visitation and those sorts of things. But most people think, if I put it in my will, then it's valid. And if that spouse is still out there, it's not. And the most important thing to know is that if it's a spouse or a parent, I say spouse, but it could be a parent that's not a spouse, right? If it's a person that's the child's parent on the birth certificate and a named parent, that person has very specific constitutional rights.
Mm-hmm.
And the courts are very lenient towards those constitutional rights.
Mm-hmm.
And so in order to terminate them, people have to go through a process called a TPR, which is a termination of parental rights.
Mm-hmm.
And it's critical that if there is that sort of absentee parent and you know that you're either sick or you're concerned about this, moving forward, you need to move forward with that TPR process before your death and make sure that you can then guarantee who that designation is going to be.
Right. Yeah, I often find that sometimes my clients think that they can leave their kids the same way they can leave a bank account to a person.
Or a cat or a dog.
Yeah,
or
it's not the same
It
thing
isn't
at
the
all.
same thing at all. Because of the constitutionally protected status that parents have, the other parent, if it's a named parent, on a birth certificate, or that parent's, the parenting has been established, then let's call a legitimation proceeding. If that's occurred, that parent has an equal right to that child, absent some other type of order.
Okay. Well, thank you very much, Evonne, for being here. Can you let our audience know the best way to get in touch with you?
Absolutely. I'm Evonne Hopkins of Hopkins Law Firm. We're in North Raleigh at on Falls of News, just north of 540. We have a website. It's www.raleighLawFirm.net, and my number is 919-268-4070.
All right. Thank you very much.
Thank you.